the answer to that question doesn't seem clear right now, and it should have a clear answer. We should know, we should be able to predict in what cases would a lawsuit be allowed to go forward.
Welcome to the Center for AI Policy podcast, where we zoom into the strategic landscape of AI and unpack its implications for U.S. policy. I'm your host, Jacob Kraus, and today's guest is Jason Green-Lowe. Jason is Executive Director of the Center for AI Policy, where I work, and our conversation focuses on who is held legally accountable when AI causes damage or harm, how they're held accountable, and potential policies to clarify or improve liability law regarding AI. I hope you enjoy. Jason, thanks for coming on the show.
Thanks for having me.
To start, what got you interested in the AI space and AI?
So I started off doing a little bit of machine learning on the side to support my legal career. I was working on subprime mortgages at a legal services clinic, and we had to prove that the bank was giving cheap offers to homes that were being foreclosed on because they could pick up the homes kind of at a steep discount if the buyer didn't have any other options. But then that meant the buyer didn't get much money from the sale and the bank could walk away with title to the property. But how do you know it's a cheap offer? Nobody else is bidding on it. It's not obvious what the price should be. This was before Zillow, and you could just look up what you would expect the price to be. So I built a model. I built a regression model that would predict what the price of the home ought to be based on the number of square feet and when it was built and how many bathrooms it had and so on. So we could see statistically, okay, this is actually well below what we would expect market price to be for this home. And I kept on working with these kinds of models to predict how many accidents you'd be likely to see if a corporation was taking safety seriously, or what's the fine likely to be on this lawsuit, or how might somebody vote at the United Nations. And so I just sort of drifted into artificial intelligence as the field evolved and as it got more sophisticated and able to do a wider variety of things.
Right. And going from those statistical models to leading the Center for AI Policy, where we're both at, is quite a transition from the technology side to the more policy side. But you also have a big background as a lawyer. So when did you start thinking about liability? And then we can work into how that fits into the AI space.
Yeah, great question. So I want to tackle each of those in turn. The first question, how did I make the transition to kind of doing full-time AI policy work? As I kept working with these models, it became increasingly clear that they were going to be an important force in our future, right? So it's one thing if the model only responds to your specific questions and makes a statistical prediction, but we've already moved past that older era of classifier machine learning where it's just making a prediction, is this a low price home or a high price home, and into the realm of generative AI, where AI is producing images and poems and songs in response to a prompt. And very soon we'll be moving into the next generation of agentic AI, where the AI can pursue a goal on its own and sort of take actions in the real world to make that goal come to pass. As I just continued my research into the area to stay current in the field, I felt that the consensus was that it was not a safe technology, that the people developing the technology felt it was unsafe, the people studying the technology felt it was unsafe, and that not enough was being done to develop public safeguards to keep these agentic AIs from taking actions in the real world that could hurt people, maybe millions of people. So that's why I wanted to get involved in the field full time in terms of focusing on AI policy rather than continuing to do litigation. Along the way, I volunteered for the Future of Life Institute, for the Center for Long-Term Cybersecurity. I helped facilitate a class on AI policy with Blue Dot Impact. So I had a period where I was sort of ramping up on the nuts and bolts of the field in terms of what had been done so far and what was being planned. And now I'm very excited to be working with the center, where,
Yeah.
as you say, one of our major policy areas is trying to reform liability, trying to make sure that companies can be held responsible financially for the effects of their actions in the AI space. And that's really all liability is. It's a very fancy word that means if you harm people, you should be one of the people who has to pay for the costs of that harm, as opposed to the costs all falling on the victims.
Great. And what would be a textbook example of liability to paint a picture of what this actually looks like?
So one of the places where people encounter it the most in their daily lives is car accidents, right? So you run into somebody at a red light. So who pays for the costs of repairing your car, for the hospital bills, for any time you miss off work? Usually it's an insurance company. So the insurance companies will argue over, well, my customer was liable. No, your customer was liable. How are we going to split the liability? Is it 50-50? Is it a no fault state? Is it all the fault of the person who rear-ended the other driver? That's kind of a textbook example to get you thinking about it.
Yeah. What
Another, yeah,
about one without insurance?
yeah. So uh, we used to have uninsured workers across all of our heavy industries. So you had workers in the mines, workers in the factories, workers in trucking and so on, and they'd be losing a hand or uh, having broken bones and sort of missing months of work while they heal, and that was just on them. There was no liability. If you were hurt at work, that was your problem. The thought is, well, maybe you should have been more careful, even if the machinery was designed in a way that was fundamentally unsafe and was injuring people who were pretty cautious in their everyday lives.
Yeah. Now, in that case, and in the case of AI, it seems like there might be a very large company that is then taking the liability burden. So, does that effectively deter companies from repeating their actions, unsafe practices, etc.?
It can. One of the problems we're having the last few decades in America in the civil judicial system is that decisions are slow and they're uncertain. So one example is the Microsoft antitrust lawsuits of the early 2000s. It's a little absurd that I can refer to a case that went on in the early 2000s, right? These cases literally take several years to resolve. So while you're waiting for the lawsuit to resolve, if you're the plaintiff and you're the one suing, you don't get any money, right? You're just sort of waiting around hoping that someday you'll eventually get some money. And at the end of that process, you might have to settle for pennies on the dollar. So you're suing for $1 million, but you're going to go home with only 20 or 30,000 because you can't wait anymore, or you know that you might lose the lawsuit on a technicality or because of a legal rule. So the deterrent effect on companies is there's something there. They behave differently when there's liability on the books than they would if there were no liability at all. But there's not as much safety as you would expect if companies knew for sure that they would be footing the bill for whatever harms they cause.
Okay. I've seen some pretty big fines coming out of Europe. I think one recently was $250 million for training on copyrighted data for AI. And that's in the realm of intellectual property. Would you also include that in how you'd think about liability as a deterrent for AI companies, or is that from the legal field more considered separate?
No, copyright can be a kind of liability, especially civil damages for violating someone else's copyright. And in fact, copyright is one of the more effective areas of the law in terms of punishing and deterring companies that steal other people's data because the penalties are so draconian, right? You can be fined maybe $250,000 for each instance of willful copyright violation. So if you're mass copying other people's books or libraries, that $250,000 here, $250,000 there, pretty soon you're talking real money. Even if you have to settle that at 10 cents on the dollar, it's still a lot of money after the settlement. The challenge is some of these companies are too big to fail. So you have the Google Books settlement from around 2008, where they essentially Google Search just copied every book in the Library of Congress without really asking for permission first. And then people had to figure out, well, what should we do about that? Should we go and allow these copyright holders to sue Google for copying literally every book they could find? And I think the eventual result that the political system came to was, no, we don't want to impose that kind of damages on Google. We like having Google Books around as a product. But what about the copyright holders? And they're just out of luck. They're not able to enforce their intellectual property. So copyright is a powerful tool, but it's not guaranteed to be enforced.
Okay. So the picture you're painting is one where liability across the board is not stringent enough. Are there cases where you think it's too stringent, or is that a fair characterization?
There's cases where it can be too stringently applied. Also around 2008, you had the Napster enforcement, right, with the Recording Industry Association. And so I believe they went after, some 9-year-old girls saying, okay, they downloaded music illegally, they owe us $3,000. Well, that might be a little excessive. The 9-year-olds probably have some other way of learning how to respect other people's property. But in general terms, I think we probably need stricter enforcement of liability on the companies that are causing harm.
Yeah. I think people sometimes object that we would be drowning in lawsuits. We're such a litigious country. But in the case of the largest AI companies, these lawsuits would be quite small in total number, since there's just not that many companies that can build a massive $100 million+ AI model. Would you say that's roughly the way we should be going with liability, is we should be targeting it on the companies? Because I know people are also saying, well, what about the people who misuse an AI system at the end user level?
So people who are consciously deciding to misuse AI are worse morally than companies that just carelessly release an AI that somebody else might later misuse. So I do think the person misusing the AI should be the first point of intervention. If you can get your damages made whole by suing the person who intentionally misused the AI, they're a better target. However, they often don't have enough money to satisfy all of the damages. Part of why the Center for AI Policy is trying to regulate this technology is one person acting alone might be able to misuse an AI tool to cause, tens or hundreds of millions of dollars in damages. And we have a saying in the legal industry, you can't get blood from a stone, right? If they don't have that money to pay you back, you need someone else to get it from. And at that point, I think going after the company that carelessly made their products available for everyone to use without testing them adequately to see if they were safe should be the backup payor to make sure that their victims do get made whole. I
So
also
let's
want to
go
rewind to
ahead.
your previous point for a moment about, are we going to be drowning in litigation?
Sure.
We can simplify a lot of the processes for litigation, and we should, right? There's no reason for these lawsuits to be dragging on for years. Some of them should be a simple hearing, get it over and done with in one session. If we had cases that were a little more like Judge Judy, where she hears what people are saying and then issues a decision and then it's over, then I think it would be less of a burden that people tend to litigate. Because sometimes you do get sued over something that's nonsense. I had clients who wanted to sue because somebody looked at them the wrong way. I turned them away. I said, no, I can't represent you for that. But not everybody will. And so it's fine to have protections against nonsense lawsuits. But we also need people to be able to get some compensation when they're badly hurt by real problems.
Okay. Now, can you dive into what's the state of liability as it stands, absent any legislation getting introduced or passed, absent future court cases getting settled? what do you think would happen right now to companies like OpenAI or Google in the specific arena of their AI systems being misused or autonomously acting to cause harm?
I think we're in a real gray area, right? There's a tremendous amount of uncertainty, which is bad for economic efficiency. Right? So we don't know whether OpenAI or DeepMind or so on would actually be held liable. There's a lot of different ways they could dodge a legal judgment. A judge might decide that the particular harms that happened weren't reasonably foreseeable. They might decide that the product was safe enough if it was used as intended, and it was only because it was misused that it caused any harm. A judge might decide that, uh, sure, the company's responsible, but it was also other people's responsibility to mitigate their damages, and they should have had better cybersecurity so they didn't get hacked. Or it might just drag on for years until somebody pardons it or passes a law granting immunity. Uh, some of the people who are in need of compensation might not get it in a timely fashion. The companies themselves might cease to exist. Maybe they sell off their assets, they pay their investors, then they reform a new company 8 years later with new venture capital to do some new technological thing. The speed at which these lawsuits are resolved has to match the speed at which the technology and the businesses are changing. Otherwise, it doesn't do much practical good.
Yeah, you've bounced a few times on how long the lawsuits can take. Is that something that Congress can affect, or is that more up to how the legal process has been working and will continue to work?
Most civil lawsuits happen in the state courts. And so the several states will mostly have to take responsibility for finding ways to speed things up. There's two things Congress can do. One is they can hire more federal judges. Right? So if you open more courthouses, have more judges, more clerks, you can process the cases more quickly. And that would help some because some of the cases are federal. The other thing they can do is they can create a private federal right of action that allows people to sue in federal court for particular kinds of harms. And so then if you keep that cause of action very simple, very straightforward, very clear, you minimize the legal hurdles that people have to jump through to get relief that way, you could create kind of an express lane where people would be able to quickly get some compensation for their injuries.
Yeah, it was surprising to me when I found out that that's not the default, that people can't go out and sue if they feel like they've been harmed by an AI system. Am I understanding that correctly?
Well, you can sue for anything. The question is whether you'll be laughed out of court, right? So is there a right that you can enforce? Do you have the ability to enforce your rights in court, or is your complaint just going to be dismissed without anybody considering the merits of the complaint? And there's a few reasons why it might be dismissed. One is maybe it's a matter for the states. And so if you bring your lawsuit in federal court, you'll be told, well, no, get out of here, go sue in state court. Or maybe it's not something you can sue about at all. Maybe it's a matter for elections or something like that. One of the interesting examples is sewers. So I was researching a case recently where they had a sewer pipe that was running past their house, and it's supposed to be dug at least 6 feet under the ground so that you don't really smell it. But the city laid the sewer pipe only 4 feet under the ground, and so they thought they could smell the sewage, and it was bothering them. And so they tried to sue the company that put the sewer pipe in the wrong place, saying, hey, this stinks, and you're not following the rules about where to put the sewer. Because there's a city ordinance saying you have to put it 6 feet down. And the city came back and said, look, that's our business. This is not the business for a private lawsuit, right? We said it has to go 6 feet under because that's a public health issue. That's how you make sure it's not leaking into the general water supply. But whether you don't like the smell of it, that's your problem. That's not something we were trying to create legal rights about. So you want sometimes this distinction between is this something you want private citizens suing each other over, or is it just something that's supposed to be hashed out by a particular public agency?
I guess there could be some people relying on law that applies to particular non-AI areas. For example, if someone uses AI to find a nice scam email template and sends it to me, and I fall for their scam or whatever other cyber offense scenario you might use the AI to assist with or carry out mostly on its own for you as a bad actor. If someone did that to me, would I be able to sue them because you can't do fraud?
Yeah, it's a great question. So part of why the center is pushing for liability reform is because the answer to that question doesn't seem clear right now, and it should have a clear answer. We should know, we should be able to predict in what cases would a lawsuit be allowed to go forward. There's a point where it's too general, where the AI is just serving as a general purpose tool. One of the examples I got when debating with some libertarians about this is a pencil, right? So if I take a pencil from Bic or whoever makes them and stab somebody with it, is Bic liable because they made a pencil and I found a way to use the pencil as a weapon? Probably not, right?
Almost definitely
99.99%
not.
of the
Yeah.
time. Yeah. Like almost all the time, the pencils are used safely and responsibly. There's nothing particularly useful that makes the pencil into a great weapon. I mean, maybe I can sharpen it, but I could sharpen anything. So that the company's not really enhancing my ability to cause harm versus just having a stick. And so just because someone was tangentially involved in some harm that I caused doesn't really make me liable. However, if the company knows that something about the way the pencils are designed is attracting children to them and making the children, want to use them as weapons. Maybe they have a line of action figure toys showing everybody fighting with pencils or something like that. Then there could be some kind of case that they're encouraging that kind of violence. So same thing with the scam tools, right? If your AI can make any kind of email at all, and maybe you're not really liable if somebody happens to use it to compose a scam email that's about as good as anybody else's scam email. But if your AI is unusually good at writing scam emails, if it seems to have been optimized for that task, or if it seems like it was pretty foreseeable that someone could optimize it to make better scam emails than anyone else would be able to make, or to make them thousands of times faster than they'd otherwise be able to make them, then the question is, what did you do to prevent that? You release this new tool that changes the threat profile for the rest of the country. Did you take reasonable steps to put safeguards in place? Or did you make it so that anybody can just, use it for whatever they want?
It seems that the key principle here is one of what would have happened otherwise. So with a pencil, it's not very hard to substitute that for a knife or something else that's sharp. If someone has the mind that they want to go commit a crime with the pencil, they could have used something else, and not much would change if the pencil wasn't there. And so your argument, and this is something I would argue as well, is that if you build an extremely powerful AI system that can interact with, for example, areas of critical national security like nuclear weapons or biological weapons in the future, then this is not something you would be able to easily replace. Whereas now it seems like maybe you can use Google to replace the answers that you'll get from ChatGPT. If you're a pretty enterprising Google user and you have the spirit to search around. So is there a way we can distinguish between liability for different kinds of AI systems?
Hmm. So I think you're precisely right about that kind of but-for test or counterfactual test. What would have happened with an AI system and what would have happened without it. And if there's a big difference, then you want the companies thinking hard about how to keep their product as safe as possible and putting some real safety features into place there. What kinds of differences in AI systems are you thinking of?
Yeah, well, one simple thing that's in the White House executive order is if the AI system is trained on 10 times 10 times 10, 26 times, 10 to the 26 operations, then some reporting requirements apply to it. And we've seen in Europe as well, I think they use 10 to the 25 as their threshold. And so they applied different regulations to the system depending on how much compute it was trained on. So can that work in liability? Can you tier it?
You can tier it. Part of why our model legislation and some of the acts you mentioned use these compute thresholds to classify the amount of risk or concern behind an AI system is you have to give fair notice to companies that are being regulated that they're subject to a regulation. Right? You can't just say, oh, if you make a dangerous AI, then you have to follow these rules, because how do they know if it's a dangerous AI? Maybe they thought it was safe. You wouldn't want an unfair surprise where they're subject to all these laws and they didn't even know it. So the nice thing about the compute thresholds is the company knows how much compute they're using to train a new model. For liability, you can actually afford to be more flexible. What you're really saying is it's on you, company, to decide how much risk you'd like to take. If you want to train your model with 10 to the 27th or 10 to the 28th flops and not have any safety precautions, that doesn't necessarily directly affect your liability. Instead of being liable based on how much compute you put in, you're liable based on the consequences. If you cause harm, if your product causes harm, more harm than would have been caused without your product, then you may be held accountable to pay for the damages. And so there's this neat economic balancing where the riskier your product is, the more capable your product is, the more you're incentivized to try to add more safety features to avoid having to pay out judgments and civil lawsuits down the road.
And to clarify that, there's not much precedent for law that targets specific features of the technology itself. So this tiering system wouldn't be a very normal thing to do.
It'd be a little unusual. You sometimes see a declaration that a particular kind of technology is inherently dangerous or extraordinarily dangerous. So you might see that for fireworks or certain kinds of blasting equipment used in mining and tunneling, or for keeping wild animals like lions around. It would be totally reasonable to compare some of the more dangerous kinds of AI to those categories. AI can be like a wild animal in that we really don't understand in any reliable way how to get them to do what we want them to do all of the time. Sooner or later, they're likely to do something unpredictable, and that could be dangerous because they're powerful. But no, it's usually not based on these kinds of numerical thresholds in civil liability.
Okay. And can you base it on compliance with government regulations? So if you set up a permitting scheme where you have to get a permit to deploy your model widely, would the liability be able to soften if the government gives you approval and says, yes, this looks safe, and then it ends up not being safe?
Yeah, absolutely. That's much more common. That's what's called a safe harbor provision.
And would you support that?
I think there's ways of making that work. Yeah. I one of the hopes we have for the liability reforms in our model legislation is that it will supplement the regulations in case the government missed something. So the government's never going to know in advance all the things you have to do to make a product safe. The company is always going to have some private information about their opportunities and their costs for making a product safer. So the government, it's the same reason you want a free market and not just a command-based economy where the government makes all the decisions. The company is going to know something that the government doesn't know about opportunities for making their products safe. By passing the costs along to the company through civil liability, you give them the right incentive to use that private information to keep their products as safe as they know how to. So some kind of safe harbor might be appropriate to encourage people to comply with the regulations, but some amount of liability probably still also makes sense so that companies have the right incentives to use their private information.
Now, in the Center for AI Policy model legislation, do you have a single liability provision that you think is the most important? And can you walk through why you think it's needed?
Yeah. The rule I'm most excited about is joint and several liability. And that's the idea that all of the people who contributed to creating the AI system that causes the harm should collectively be responsible for paying the damages caused by that harm. Because there's going to be a lot of collaboration between companies and actors of all different degrees of sophistication. Right? That's part of what happens when you publish your model on the internet for anonymous people to download. That's part of what happens when you have an API that allows millions of different customers to use your product and apply it in creative ways that they think of. So if you're not vetting those customers to make sure that they're responsible, that they're bonded, licensed, insured, able to pay for any harm they cause, then you too should be on the hook for helping make sure that any victims get compensated. And so that's the joint and several liability idea. We talked a little bit about it earlier in the show.
Yeah. And to summarize it, it's that if you can't make a rock bleed, is that the analogy you
You
used?
can't get blood from a stone, yeah. Right. So
Then
some of the
you,
people who are most guilty, some of the people who have caused the most harm, will be essentially broke, right? It could be some teenage hacker in a garage. So how are they going to pay if they've taken out the power grid for an entire state? That's not a reasonable place to go looking for financial damages.
right. And this would ensure that if you can't get liability from one source, then there are other sources to turn to compensate you for your damages.
That's the idea. You
Okay.
all work together to make the harm possible, so you'll all have to work together to clean up after yourselves.
And what would you say to someone who is critical of this proposal? Can you anticipate that there might be some pushback, and what would you argue in response to that?
Yeah, and so one pushback that we hear is that, well, we should go after the people who have intentionally misused the product first. I have no problem with that. Absolutely go after them first, but then after you've gone after them, if they're broke, you should be able to follow up with the other companies. The second most common criticism we hear is, well, if companies knew that they would be on the hook for what every random person did to misuse their products, they wouldn't develop these products at all. And the argument there is maybe they shouldn't. Right? If it's truly unprofitable to develop a particular AI system, unless you can pass the costs of development along to innocent bystanders, why would we allow that? Right? Why would we want a system that causes more harm than good when you add it all up on the scales?
Okay. Is there another piece of the model legislation that you're particularly excited about?
Sure, yeah, we have some provisions that are meant to streamline the the litigation process so it goes more quickly and more reliably. So normally when you have a lawsuit, there's many different parts of your case that you have to make out. You have to demonstrate to the judge and the jury that, that element of your lawsuit has been satisfied. So you have to satisfy the jury that your harms were caused by the particular thing that the defendant did wrong. And you have to satisfy everyone that the harm was foreseeable, that the defendant should have known better and that they should have been able to tell that it was going to cause problems. And you have to show that there was something the defendant could have done about it, that they could have rolled out a safer model. In many states, you have to actually give an example of what that model is and say, hey, here's my expert witness. He's a computer scientist. Here's the product he would have built that would not have caused these harms and would have still been just as profitable. And you have to show that you've suffered particular damages, that the way you were affected by the harms has a dollar value, and that we can all tell and agree on what that dollar value of damages was. And if you miss any of these steps anywhere along the way, you get nothing usually, right? You just lose the lawsuit. You wind up paying for the other side's attorneys, perhaps. You've wasted all the time and money you spent paying your attorneys. So our model legislation would streamline many of these requirements so that if you can show that you suffered some kind of tangible harm from the AI, right, that you lost your home or you lost your business or your relative was killed or something like that, and that it happened because someone else built an AI that was harmful, that's good enough, right? Stop there. If you can show those two key elements, that someone else made a dangerous AI and it caused you tangible harm, that should be enough that you should be compensated for that.
One part that stood out in that list is that you need to demonstrate that you could have built a product that is just as profitable but safe. First, is that the right hearing of what you said?
Maybe not literally just as profitable, but still sort of following the same business model. You need to show that there was a viable business alternative that would have been safer.
That seems strange because what if all the business alternatives were unsafe?
This isn't every avenue of liability, but for many of them in many American states, that's the law. If you can't show that there was a better way to do it that would have allowed the business to continue, then that's just your problem as the person who is hurt.
Wow. Okay. It seems like with AI, there could definitely be a system you build that makes tons of money because you're integrating it in all sorts of businesses. It's the leading AI model in the world. And then someone uses it to launch a giant large scale cyber attack. And then there wouldn't have been a way to build it safely while still having such an amazing product that gets used in all sorts of other industries. And then the company would be exempt from liability in that scenario.
There might be other theories of liability. There might be some way of pursuing the case. But yeah, there are lawsuits that would be ended by that kind of defense, where they say, look, we did the best we could with the safety features that were available. And I don't think that's the right standard. I think instead of just saying we did the best we could with the safety features that were available, I think you should slow down just a little bit, enough to build enough safety features that you earnestly believe that your product will be safe, that it won't, cause massive cyber attacks that take out the stock market or the banking system or the power grid.
Yeah, it stands out to me a lot because some people are worried that once we build AI systems that pass a level of capability that could do some of these large scale cyber attacks, that maybe the safeguards we've been using along the way no longer work because the system is now qualitatively different. It's a much different kind of machine than the one that the safeguards are working on now. Seems like this is a potential loophole that needs to be fixed.
That's why we're here. We're trying to plug that loophole.
Great. And stepping back from the specific policy proposals and more on this theme of how AI is continuing to evolve, how do you think liability law might need to evolve with AI? Is it the case that passing this model legislation is more or less going to be future proof? Or do you think there are future plausible kinds of AI systems that will require more rethinking and restructuring?
We'll probably need more restructuring over time. If we're right about where AI is headed, the future is going to be a strange place. We might see AI stepping into the role of lawyers, into the role of judges, maybe even into the role of writing some of the laws or regulations that we wind up using. Uh, and I'm sure we'll have new AI models at some point, right? I mean, the transition from machine learning to generative AI was a surprising one, even for many people who were deeply steeped in the field. There could be a new AI paradigm next year or in 3 years, and that could have new effects that'll need new liability reforms. But it's unlikely that they'll press in a contradictory direction. In other words, we still have big data today. That hasn't gone anywhere. And it's not like the machine learning tools from the aughts and the 2010s have stopped being used in our economy. They're still there. So whatever harms they're causing, we still need reforms to address them. It'll be the same way with generative AI. Right? Whatever liability framework we develop to address the harms of generative AI, we'll still need that framework even after the next set of AI innovations occur.
Okay. And before we wrap, is there any other topic you wanted to bring up or something you wish I had asked you about?
So I feel like no discussion of AI liability would be complete without at least touching on Section 230 of the Telecommunications Decency Act. Right? A lot of the debate in Congress has been focused around who should have Section 230 immunity, why, who should have it taken away, why. The basic idea behind Section 230 is that if you're the equivalent of an electronic bulletin board, you shouldn't be liable for what people post on that bulletin board because you have no practical way of monitoring what everybody's saying. You have no practical way of stopping them from saying things that are obnoxious, offensive, libel, whatever it is. And so if you're running, Yahoo News, or if you're running Facebook and other people post their own news items to Facebook, you as the host of that content are not liable for what other people say on your bulletin board. Fair enough. I mean, that's had some unpleasant social consequences. Some people have been hurt by that. But I think there's a good argument that in the long run, the freedom to run a bulletin board has done more good for society than the harm that was caused by particular people saying nasty things online. Where that falls off is where the content is so aggressively curated that it's no longer accurate to describe the service as hosting a bulletin board. So if instead of passively waiting for other people to put some content on your website, you have an AI algorithm that is determining what you think your customers want to see and showing them exactly what you think they want to see, or showing them exactly what you think will generate the most ad revenue,
or showing them content that they didn't choose to follow is a trend we're seeing more.
Yeah. And there's nothing wrong with broadening your experiences outside your social bubble, but if you're going to decide what somebody else wants to see, you're not really a bulletin board anymore. And so at that point, the argument for immunity starts to look pretty thin.
Okay. I thought you were going to bring this to how maybe Section 230 doesn't apply to generative AI. Is that stance you still consider to be true?
Well, depends what the generative AI is doing, right? So if you're creating new content, if you're writing an essay and posting that essay on somebody else's wall or something like that, Section 230 never would have protected you, right? Because you're not the host of that content, you're the generator of that content. That's what the generative in generative AI means. If you're using something like generative AI to help you decide what content to show someone, that's probably the kind of aggressive curating I was talking about, where you're shoving other people's content in someone's face, not just passively allowing it to exist on your bulletin board.
Now, is there anywhere the guest should go to learn more about your work?
Yeah, I mean, we recommend that people go to aipolicy.us. We've got a blog that kind of follows our postings on requests for comment and sort of following along with some of the important legislation that's being considered. We've got a newsletter that we encourage people to subscribe to. Do you want to tell our guests how to subscribe?
I write a lot of that newsletter. The way to subscribe is AI Policy Weekly. You can type it into Google search and you should find it on Substack. You can also go to the website and then click on Join Newsletter button.
We're also on LinkedIn, we're on X, and if you're in Washington, D.C., we'd love to see you at one of our monthly happy hours or one of our congressional briefings.
Great. My guest today has been Jason Green-Lowe. Jason, thanks for coming on.
Thanks so much for having me.
Thanks for listening to the show. You can check out the Center for AI Policy podcast Substack for a transcript, links, and more. And if you have any feedback for the show, please shoot me an email at jakub@aipolicy.us. Looking ahead, next episode will feature Katja Grace of AI Impacts, discussing the future of AI and what AI researchers who have published in major venues think about it. I hope to see you there.